everybody. We'll go ahead and get started. Thank you all for coming. Really appreciate it. We have BZA members here, and we have Planning Commission members here. I'll tell you before I introduce George, if we could just go around the room, just so everybody kind of familiar with everybody. I'm Keith Free. I'm the Planning Director.
Ty J, BZA since 2018.
Thank you,
Paul
Ty.
Guthrie, Zone Appeals.
Good to see you, Paul.
Good to see
Mayor
you.
Jamie Cleary, one of the reasons I'm sitting up here is so I can see that screen better. We were actually thinking about putting some monitors on the desk up here between every two seats. And one of the reasons is because y'all, just like the board, have to focus a awful lot up there. But what we do is we put the monitors here that we have the same thing there. Is that a value to y'all?
Yes.
Y'all
Yeah.
Okay, sorry, that was my introduction. That's the question.
Thank you, Mayor.
Tim Altizer, I'm on the board of zoning, sorry.
Jeff Coker, Planning Commission.
John Evans, Planning Commission.
Vanessa Silkwood, Planning Commission.
Charles Hasty, Planning Commission.
Awesome. And I'll just have the staff just say.
Grant Green, Senior Planner. Scott Benham, Hendersonville Fire Marshal. Jay Winterbeck, Economic Development, Community Planner.
Timothy Whitten, Assistant Planning Director. Stephen Winsonreed, City Engineer.
Sydney Simpson, Planner.
Thank you very much. I appreciate the staff being here. George Dean is with us this morning. George is an attorney. He's very he has a very in-depth knowledge of zoning law and has practiced that for several years.
A long time.
And he's got a lot of insight to some of these different legal things that we deal with. And we had our training last week. We had the 2-hour training with Sam last week, and we have recorded that. So if you didn't attend that, let Lauren know, and she'll have the link, or she may have already sent that link out. But the Planning Commission and Board of Zoning Appeals members are required to have 4 hours of continuous training every year, and this is a part of that requirement. And I will just jump in, just let George go ahead and jump in, and he's going to share things. And as we're moving forward, if there was a specific question that you had about something that he's discussing, just let him know. We'll just do this informally, and we'll go ahead and get going. Thank you, George.
Sounds good. Thanks very much. As Keith said, my name's George Dean, attorney, Tune Inchker and White. I've practiced in Nashville for over 40 years. That's why I'm sitting. I can't stand as much as I used to. I started out with Metro Nashville in the legal department, represented the Board of Zoning Appeals, represented the Metro Planning Commission, the Historic Zoning Commission, Department of Codes. I was there only 3 or 4 years, then left to go into private practice and have done in private practice essentially what I did with Metro, represent folks in front of the Planning Commission, the Zoning Board, Historic Zoning, and as a consequence, we wind up in litigation fairly frequently on land use planning kinds of issues. So that's kind of what we're going to talk about today. I'll try. I don't know what Sam talked about last week. Sam's an old friend. In fact, in I think it was 1981, Sam and I testified in a case over in Wilson County. I'm not sure. I think Sam was probably the planner for the Board of Zoning Appeals. It was a conditional use over there. They call it I'll just say conditional use special exception. They've got another word for it over in Lebanon. Use permitted on appeal, I think is how they say it there. Same idea, though, that if you meet the requirements of the ordinance, you're essentially entitled to the permit. And so Sam and I wound up testifying. The case ultimately went to court. Folks for whom we were testifying at the time prevailed in the trial court, and then the case was appealed to the Tennessee Court of Appeals. And Sam never stops kind of kidding me. Got up to the Court of Appeals, and the Court of Appeals judge said, well, this attorney, Dean, testified, and what does he know? He doesn't know anything. He's just a lawyer. But Sam Edwards, there's a planner. He really knew what he was talking about. So, yeah, Sam, for 40 years I've had to listen to that. Anyway, Sam's a great guy, extraordinarily knowledgeable. If I start going over the same stuff he talked about, and I don't know exactly what he talked about, so if I hit some of that, we can kind of change direction a little bit, because both Sam and I have done a lot of these seminars over the years and have a fairly wealth of knowledge about this kind of thing. What I thought I'd start with is just talking a little bit, and really the theme throughout our couple of hours here is looking at those instances where the boards, the zoning board, planning commission, have either the kind of discretion that they have in order to make the decision. There's some situations where there's fairly large amounts of discretion to make a determination. There are other areas where it's more limited, and so kind of having a reasonably good grasp of those makes it a little bit easier for you to know where you have to be a little more careful and where you don't have to worry too much about the possibility of an appeal. I don't know that you get cases where they go up all that much here in Hendersonville. I will talk, I don't know whether Sam hit that, your Airbnb case from a few years ago. I put it on at the tail end of the seminar. I thought I'd just mention it.
He didn't hit that.
He did not? By the way, did the case go up on appeal? I know it was locally decided here in trial court here in Hendersonville, but.
It did, where we are with vacation rental, and it's kind of confusing out in the community because I believe there was an article about that it lost on appeal, so the city lost, and then everybody assumed, oh, well, the court's determined you can have vacation rental, but that was retracted.
Oh.
And so basically, it stands that our ordinance is currently, that our ordinance is valid, and there's nothing wrong with it.
Well,
And so we've been enforcing it, really, I guess, since that happened, for about 3 months now.
We are
So,
collecting fines now.
and we are
Okay.
collecting fines, so we're collecting thousands of dollars in fines.
Well, I
We just
guess-
had a fine for a property that sold. We had, I think, over $10,000 in fines that we just collected. So if anybody out in the community is kind of confused, nothing has changed about our vacation rental. The court has upheld, but everybody there was another article that kind of explained it, updated that, but I don't think very many people read that when they all read that first article.
Who's the city attorney again? I've forgotten, I'm sorry.
John Bradley.
Yeah, I talked to
Yes, sir.
John. I heard about the case and called him, and he sent me a copy, I guess, of the original opinion. I guess I need to talk to him and get a copy of the update. He kind of explained there was kind of an elongated history with the case. And I might just mention it maybe to start off, although it doesn't neatly fit into the wide discretion versus limited discretion, because I'm not sure, well, the Board of Zoning Appeals might hear cases arising out of it, I guess. There's not a special board with an appeal on one of the Airbnb cases go to the board?
No, nothing with Airbnb would go to the
Okay.
Board of Zoning Appeals. It used to be, the city ordinance used to have it as a conditional use, but then we changed it as a conditional use and just had it in the zoning ordinance.
Yeah, okay.
And limited it to a couple of zones where you could actually do it.
Right,
Every
okay.
place else, you couldn't do it. And then when we're talking about vacation rental is renting your whole house out. So that's the definition in the zoning ordinance. But if you rent part of your house out and you're living there, you can do that through vacation. It's really vacation rental, but it's not by our definition.
Yeah, right. Well, and the situation in Nashville, for example, is that somewhat similar, because they found that if the homeowner was there and they're just renting out a part of the home, not nearly the kinds of problems that occurred if they were renting out the whole house and the homeowner's gone someplace. People tended to do things that, disturb the neighbors and the neighborhood, so. Well, and I was just going to mention the case because, and I have I've forgotten who decided the case, but I have a high opinion of the judge who did it, not the local judges, at least the copy of the opinion I've got, where the judge decided that the ordinance was unconstitutional. The other judges, the local judges in Gallatin, recused themselves and didn't hear the case. Now, it may have gone back to one of those, Louis Oliver maybe, or I think it's Joe Thompson's the other circuit court judge. But they called in a special judge as a result of Louis and Joe recusing themselves. And we're going to talk about the same judge in another case as well today, because he decided a case that I was involved in Nashville a few years back as well. And in that case, did a very fine job. But I was surprised in the Airbnb case, the vacation rental case from Hendersonville, because essentially, if you're dealing with a challenge to a zoning ordinance, what the courts ordinarily do is, unless there's some specific type of a right that is threatened by the ordinance, and usually you're thinking First Amendment under those kinds of scenarios, a situation where the zoning ordinance has some impact on freedom of speech, perhaps a religious kind of a problem as well, that's also a First Amendment issue. Those are the usual kinds of things that can turn up, and in those cases, the court applies a higher standard to judge the ordinance. They look to see if there's some real compelling reason that the ordinance is necessary for the community to enforce the law. In most zoning cases, though, the court does not use that kind of a test. They use a much simpler test, which the lawyers just call a rational basis test. And in those situations, all the court's looking for is any decent reason, any common sense reason for the ordinance to exist. So if there's any real common sense rationale for the ordinance as adopted, then the court usually is going to uphold the zoning ordinance, or for that matter, any piece of legislation that is adopted by local government or state government. In this case, the judge looked at it and specifically said that the vacation rental ordinance here in Hendersonville met the rational basis test, that common sense doesn't make any sense, because, of course, it does. You're trying to control the amount of noise and kinds of disturbance in a local community in and around the neighborhood. And as a result, the city, if it thinks that there's a problem with particular types of uses, the city can regulate that. That's zoning. That's what all of zoning does. Harking back to the original case, Euclid versus Ambler Realty, back in the U.S. Supreme Court back in the 1920s, essentially they said, well, you look to see if there's some kind of a common sense reason that underlies the regulation of the real property, the use of the real property. And here, keeping uses, one use from other uses that may not be compatible is a reasonable thing for the local government to do. So as early as the 1920s, the U.S. Supreme Court held that way using that same standard. And that standard has come through all the way to today. And so the judge first held that way, that it did make a common sense reason for having the regulation on Airbnbs, but then turned and said, well, but the next question is whether or not there's a fundamental right involved. And he found basically that private property ownership is a fundamental right, and certainly that is an important right. The difficulty is that we've regulated that, and I say we, the local governments and state governments, since time immemorial, including Euclid versus Ambler Realty in the 20s. All of zoning is a type of real property regulation. And so, you can't really call that a fundamental right in the same way that you think of the First Amendment to the federal Constitution, the right of freedom of speech, right of religious freedom. And so the judge continued on and said, this is a fundamental right, and if you're looking at it as a fundamental right, you've got to show a compelling governmental interest, not just a common sense reason, but there's got to be something really, really important for the local government to enact such a law. And he just found that there wasn't anything like that in this instance, and I'm sure there isn't, because it really doesn't meet the compelling governmental interest test. It shouldn't have to. It's a regulation, like all zoning regulations, over the use of land, and it just has to pass that common sense rationale. When you're sitting as a planning committee, boards of zoning appeals members don't see this very often, but certainly planning commission members do. When you've got an application or a zoning change coming in front of you, and you're going to make a recommendation over the local legislative body about the reasonability of that zoning change. Should the zoning be changed? Should it not? Should a text change in the zoning ordinance be considered, and should it be recommended by the planning commission over to the local legislative body? Generally speaking, unless there's as I say, kind of a First Amendment freedom of speech or religious freedom issue, and that's unusual. Most of the cases that you tend to see are cases that would be judged under this more reasonable standard of, just does it make some common sense to have that regulation? Does it make common sense to change the zoning, say from multifamily residential to a low-density, a low-impact commercial? Is there a reason to do that? And if there is, if it makes reasonable sense, then the courts are going to uphold that if it's ever challenged. The plaintiff can challenge the decision either way. You can have a neighbor challenge the decision of the local legislative body adopting the zoning change, or say the local legislative body does not adopt the zoning change. Let's make it more concrete. We've got a zoning change where the property owner is asking to go from, say, a multi-family residential to a fairly low-impact commercial use, and it's on the periphery of some other commercial area. Is it an appropriate change or not? Let's assume that the Planning Commission recommends against, and the local legislative body looks at the Planning Commission recommendation, hears from the folks at a public hearing, and decides that the Planning Commission's recommendation is correct, and it decides also not to pass the zoning change. The property owner can always sue, not for personal liability for anybody, but for a declaratory judgment, asking the court to look at whether or not the local legislative body overstepped their bounds. And in a sense, that's what happened in this Hendersonville versus Allen case. The owners of the properties who were using the property as vacation home rentals were challenging that legislation. The point of this long story is that about 99 times out of 100, the government, the city, always wins on those cases. It's almost impossible, setting aside Hendersonville versus Allen for a moment, and I guess it was overturned on appeal, or another local judge overturned it somehow. I'm not sure exactly what happened there.
It was a reconsideration.
Kind of reconsideration?
And I think it was based on what you were saying about
Yeah.
looking at that more detailed. That was kind of reversed back on looking at that. It wasn't substantial enough.
Well, and really, when I read the opinion, I go, the first step that he talks about, the rational basis test and just a common sense rationale, that makes perfect sense. When he moved to the second part, I went, wait a minute. you decide which test to apply first, and then apply just that test. You don't apply both. And typically, the rationale for the two different tests in this context, and by the way, it's a little more complicated. I won't get into that, but just think of it as two tests for the time being. Goes back a long time, 80 to 90 years, another Supreme Court decision from the United States Supreme Court, basically saying that the court was going to look more carefully at cases involving fundamental rights. First Amendment is the one that comes up most of the time in zoning issues, although there are some others, or suspect classifications, situations where legislation is directed at some minority of some type, religious, racial, whatever it might be. Then the court tends to look at those with the same scrutiny as it does with a fundamental right. Because most zoning laws, not really addressed to a particular religious group or anything. They apply to everybody. Whoever owns the home, whatever ethnic group they may belong to, it applies regardless. So there's a good historical reason for doing this. It's just that the private property rights have not usually been considered as a kind of a fundamental right that approaches, say, the First Amendment. And as I say, most of the time, in cases where the Planning Commission is making a recommendation to the local legislative body on a zoning change, in effect, you're not really the final decision maker anyway. The city council is the final decision maker. But most of the time, whichever way the local government decides is best, as I say, about 99% of the time, the local government, if it's challenged, wins on those cases. Interesting, again, not in my materials here today, but an interesting case out of, it's not Shelby County. Well, anyway, down that way though. A friend of mine from Murfreesboro tried the case out of county, Josh McCreary by name. Josh is a very fine zoning lawyer. He was challenging the decision not to change the zoning, kind of similar to what I was talking about. Had kind of a residential property, wanted to make it commercial, major highway, some commercial nearby. And essentially what happened is that Josh hired some expert witnesses. It was a county case. The county hired some expert witnesses. They didn't do a particularly good job testifying. The county planners themselves essentially said that, well, changing the zoning actually wouldn't be a bad idea. They didn't endorse it, but they didn't foreclose the idea. And so I'm looking at it. I wasn't involved in the case, but I look at the decision and I go, you know, when the county planners say that it makes some sense to do it this way, that's the best case you can possibly have getting to the courthouse is to have the planner articulating grounds for the zoning change. Maybe it can go either way, but if you've got that, it makes it a lot easier possibly to prevail. I got to the Court of Appeals as about a year or two back, and the Court of Appeals upheld the trial. The trial court, you kind of assume in the county, is probably going to hold for the county authorities. That's not all the time true, but particularly in a more rural area, that certainly happens more often than not. So you kind of just forget the local trial court. But what's interesting is what happens at the Tennessee Court of Appeals. And the Court of Appeals looked at it and said, hey, there were a couple of neighbors there. They had some good points about why this didn't work. The Planning Commission recommended against it. We're fine with that. The trial court decision saying that the failure to rezone the property was appropriate is upheld by the Court of Appeals. And again, even under a very strong case for the challenger, the county in that case won. And as I say, so most of the time in a situation like this, and I'm off script by about 1,000 miles, but the idea is if you're talking about a zoning change that comes before a planning commission and ultimately in front of the local legislative body, if there's any kind of a planning rationale for the change or a planning rationale to keep it the way it's zoned currently, the city ultimately, its decision is probably going to be upheld by both the local court and the Tennessee Court of Appeals. Part of it is, by the way, that our Court of Appeals has gotten a little more, the gentleman who is writing many of these cases is an old state attorney general, a friend of my wife's an old state attorney general as well, retired, and Andy Bennett by name. Andy looks at a lot of these cases from the government's perspective, and so it orients him to where the government is at. When you've represented the government for most of your career, it makes it easier to look at it that way. But really, the common sense, rational basis test I'm talking about is something that is been around for years and years and years. If you look over the entire history of Tennessee cases, I used to keep up with them, numbered them all. As I've gotten older, I just can't keep up anymore. But say there's 1,200 to 1,500 zoning cases. Say 1,000 of those are zoning change cases like I just described. I'll bet 950 of them have gone for the local government, either a city or a county. Whichever way the city or county has decided, the courts, generally speaking, are going to uphold those cases. So there's a wide discretion there. The best way to approach it is following the planning, because if there's good planning, that puts you in a position where you've got, that's how these cases all break down. The court wants to hear from the planners how is the zoning change, if adopted, how will that affect the citizens? If it's not adopted, how does it affect the local property? And so those kind of planning decisions are important. But again, the court is really wanting to defer to the local folks on those kind of local zoning change decisions. Now, changing the text, changing the underlying base district zoning. Let me flip away from that for a second and get to something maybe a little bit more concrete for us. And that's on the, and I don't know whether.
And George,
Yeah.
that was, I think that for us, that was very helpful
Okay.
to see that if in a zone change, you know, depending on, of course, I guess the process that's involved as well.
Well, yeah,
If-
now, if
yeah.
there's some screw up, if, for example, it gets the local legislative body and they act without a recommendation from the planning commission, that's a procedural error, and you get reversed like that for that.
Yeah.
But all that does is it brings it back, the court will say, oh, wait, you skipped a step,
Right.
and they'll remand it.
Okay. Now, that was just very helpful to know that if we do everything right, and then we don't tiptoe into some of those First Amendment issues, especially on the issue of rental versus home ownership, and we open it up in that way, if we are very thorough and have clear finding the fact, whatever the recommendation is, and then whatever the ultimate action of BOMA would be, then more than likely, we're gonna be upheld and we're gonna be in good shape, even if it's challenged. And so, like what George's sharing there is that from his experience, other attorneys know that as well. And so they'll know if we have followed all the processes appropriately and haven't opened the door to something weird that they could kind of leverage, then we should be in pretty good shape. Then it should deter future litigation as well.
And these kinds of cases are, people call me all the time about this. The Metro Council last night, you know, changed the zoning on my property, and I want to sue them. Well, I can't win. I mean, if you want me to go forward, I don't want to take your money. I mean, I'm not going to win the case. I can tell you just right now. If the council made a decision like that, again, I'll look at it. If the person's insistent, maybe there's a set of facts that might work, but they're very, very, very few and far between. Switch over to site plans, subdivision plats, conditional use permits. So site plans and subdivisions, usually talking planning commission, conditional use permits or special exceptions. Which language do you use, Keith? Is there?
It'll be conditional use permits, variances, and like major home occupation permits, those are the things.
I'll hold off on variances for the next slide.
Okay.
But these three, is site plans, subdivision plats from the planning commission side, conditional use permits, or in the statute, they're called special exceptions. Same idea, and as I said, in Lebanon, their use is permitted on appeal. These are kind of the other extreme. These are situations, and from the zoning board, my guess is that you see a reasonable number of conditional use permits. And set variances aside now, because I have a different take on variances. We'll get to that in a moment, next slide. But for conditional use permits and subdivision plats and site plans, the situation's almost the reverse. There, in these cases, usually what the applicant needs to do, there's usually, say, take the conditional use permit for a moment from the zoning board side. Usually in the zoning ordinance, there's some list of conditions for the conditional use permit. And the objective of the applicant usually is to demonstrate to the Board of Zoning Appeals that it meets each and every one of those sections of the zoning ordinance. If they do, then generally speaking, the burden switches over to the opponents, if there are any, to demonstrate that there's something else that might preclude the applicant from being granted the permit. But generally, it doesn't work out that way, and so usually, if the applicant can demonstrate compliance with those, say there's 10 of them, there's usually less than that, but let's just say 10 for, take it for now. If the applicant can demonstrate that they meet all, you're 100 feet away from the closest church, or 200 feet, or whatever it might be, and I don't know, there's all kinds of different kinds of conditions that can be put in the zoning ordinance. If they meet those, then the board needs to be aware of the fact that they probably are going to need to grant the application. If they don't, generally speaking, they might get reversed. This is one of the easiest cases to get the zoning board reversed is on these conditional use permits. Let me add that in a lot of zoning ordinances, I didn't look at Hendersonville, but it's very common to have not just one set of regulations that might apply, but another set, one that's very general, one that's a little more specific. The general regulations will say something like, well, the use that's planned for the property has to be, support the general health, public welfare, and safety, just kind of large general concepts. The difficulty, and most people don't see this because it don't get much in litigation, those kinds of large concepts are usually not respected by the courts. The courts look at it and say, the local legislative body, the council, the city council, when they passed the ordinance, made a decision that this type of use could go in this type of area. The board doesn't get to reconsider that. So those general requirements that frequently appear don't really help you. It's the more specific ones that have to be complied with. The general ones are not usually given effect by the courts. In fact, there's a case out of Gallatin, I think it was about 25 years ago, on that precise point. Gallatin had four elements of very general requirements and then 5 or 6 additional ones for this particular use. The applicant met all the specific ones, but there was an argument about the general ones, and the court just looked at it and said, those are too general, they don't really apply. We're just reading those out of the ordinance, and as a result, the applicant ultimately won. The other problem for the zoning board and planning commission, we're talking about site plan or a subdivision plat, but you see it mostly in front of the zoning boards, is the neighbors testifying. And there's obviously nothing wrong with having neighbors testify. But the thing to bear in mind is that most of the time, their testimony about the future impact of the particular project is largely irrelevant. And that's because the courts look at it and say, you've got to have some level of expertise in order to predict what's going to happen once the project's constructed. So if you're just a layperson, like me, that's one of the reasons the court said, you know, this Dean guy, what the heck he's talking about? I'm a lawyer, not a land use planner. They looked at me and said, you know, he can't make a statement about what's going to happen to the property in the future. He doesn't have the background and expertise. He's just a silly lawyer. And so the same idea applies to most lay witnesses who appear in front of the Board of Zoning Appeals. Usually the developer, the applicant, has hired particular experts, and then what happens is the neighbors want to testify in opposition to those experts. They're going to lose every time on that. So you have to be careful if you're a member of the zoning board. What you want to do is look to see if there's some expertise in the neighborhood. A case that one of my current partners, Tom White, and I tried many years ago, turned on a traffic issue over in, well, it's the Father Ryan case in South Nashville. And the last person who got up at the hearing turned out to be a traffic planner. The whole case involved the traffic out on the highway they're on now. I can't pull out of my memory. And the traffic planner, though, when he stood as a member of the local community, and we thought, oh my gosh, we've been here for hours, and the last witness is going to sink us, because we thought that he would talk about the traffic impact, and he, as a traffic planner, he would have the expertise to give a valid opinion in opposition to our traffic planner. But instead, what he said to the board was, well, I'm not going to talk about the traffic or as a traffic planner. I just want to tell you about my personal concerns, which had nothing to do with traffic. And so ultimately, we were turned down by the zoning board on the conditional use permit. But on appeal, we were able to overcome that because the court looked at the testimony of the neighbors as really not bringing anything new to the equation. So you want to make sure, if you're on the zoning board, that you need another expert to testify, or if one of the conditions is something simple, you know, and I mentioned, you know, got to be 200 feet away from the church or whatever it might be, and those kind of locational requirements aren't very, there's no need for expertise there. Anybody can take a ruler basically and run it out and figure out how far away it is. And so if there's a dispute about that, if one party says, you know, we're 205 feet away and the neighbors say we're 195 feet away, well, no need for real expertise there. And so if on those kinds of elements of requirements, the zoning board can make a finding that the use is located too close to the church based on the evidence in front of it. And most of the time, the board will win under those circumstances. But if you look at conditional use permits cases as a whole over the last, say, 50 years, this is one of those areas, again, where it's harder, the board has a harder job. You need to be more specific about your findings of fact, and you need to be careful about which findings, who you rely on in making those findings, because the courts, again, look at a requirement of having some expertise to give evidence that really assists the board in those kind of cases. It's a similar situation in Planning Commission with subdivisions and site plans. I was in front of the Williamson County Planning Commission about a year and a half ago, a case that didn't go up to the, and actually this was actually one, it's CPS Land versus Williamson County on the application, on the slide here. In the CPS case, what was really happening is that, and you may have heard of this, Williamson County a year or two ago decided that they were going to move in much of the property from, in developable property in the county from 1 acre zoning residential developments, from 1 acre to 5 acres. Certainly a significant impact on anybody who's trying to develop property there. My client had submitted an application for a subdivision with 1 acre properties immediately prior to the zoning change going from the 1 acre requirement to the 5 acre requirement. Under the Williamson County rules, the fact that we had applied beforehand meant that we were allowed to go forward with the project under the old rules. So I go to the board, the Planning Commission, and I have a number of experts with me. We get a staff recommendation that's favorable to us because we meet all the subdivision regulations. But the Planning Commission members who had recommended the change to the 5 acres really didn't like us coming in with a 1 acre development when they had recommended the 5 acres. And so there's a lot of unhappiness about our application. Again, much of it turned on traffic. And fortunately for us, in a way, I had my traffic expert there, but a gentleman named Bob Murphy, who I don't know whether Bob gets up here much anymore. 10 years ago, he was in private practice. He mainly works for Williamson County, I think, these days. Bob was the traffic planner, and the question immediately went to Bob, the traffic planner for the county. So the question immediately went to Bob about our compliance with the requirements for the traffic plan, whether we'd done what was supposed to be done, and how he felt about the plan. And fortunately, I've known Bob a long time. He's a straight arrow. And he said, listen, they comply. I mean, they did everything they were supposed to do in the traffic plan. There was a concern about some portion of the property that was nearby that had not been included in the traffic plan. He said that's the way our traffic planning is designed. They did everything they were supposed to do. We still lost in front of the Planning Commission. The Planning Commission voted us down, and I appealed. This goes up kind of in a different way, and something that probably is getting too much detail for you, but I'll just mention this real quickly. In these kinds of cases, from the Zoning Board and from the Planning Commission, it goes up on the record in front of the Zoning Board or the Planning Commission. That is, somebody types up everything that was said, and that gets submitted to the court. All the plans, all the laws that apply, the zoning ordinance, the subdivision regulations, and then a transcript of everything that was said. Usually there's a tape recording going or court reporters present. And that all gets typed up, and it's ultimately sent to the judge in the case of an appeal. In the zoning change cases I was talking about before, it doesn't work that way. Usually it's a case where there's actual live proof, and so whatever happened at the Planning Commission or the local legislative body is not terribly important. The real question is there a planning basis to show a common sense rationale for the zoning change? In these cases, though, from the Zoning Board and from the Planning Commission, The idea is, did the planning commission or did the zoning board have enough evidence to take whatever action it took? And again, in my case, the planning commission ruled against me, kind of saying they were real concerned about the traffic. Well, it was hard to do that because my traffic planner said that we complied and their traffic planner said it. And so at that point, it's very difficult to get upheld. The main point here is that when you're looking at a site plan or a subdivision plat, or again, over in the Board of Zoning Appeal area, the conditional use permits, you just want to be a little more careful. It's no big deal. It's just, want to make sure that you feel comfortable with where you're at. Whereas in the case of a zoning change, the courts are not going to be looking at it very carefully at all. They're going to say, whatever the local folks did, that's fine. But in the case of a conditional use permit or a site plan or subdivision plat, they look a little more carefully. Now, don't get me wrong, there are still cases that are difficult to win from the other side. The courts put a heavy burden on the person appealing. Take again my case in Williamson County. The standard in order to win is you've got to show that the board acted arbitrarily and capriciously. And if you think about it in a, you've got an ordinary traffic light case, and somebody's had an accident and somebody's been injured, the plaintiff, the injured party, sues the person who allegedly ran the red light. All the plaintiff has to do, the injured person in that case, has to show 50% plus something that the light was red when the car went through. And in the case of a zoning change, though, that deferential standard, from my standpoint, the government really doesn't bear the burden of proof at all. It's the burden's on the other side. They still have to show that the government did something wrong, that it's unconstitutional in some way. Difficult to do, almost impossible to do, really, in that context. And then still very hard in the situation where you're talking about the conditional use permit or site plan review or subdivision plat. Instead of 50% plus one like the driver in the car accident, the courts don't talk this way, but just from a layperson's standpoint, if you think about needing 80 to 85%, maybe higher, in order to reverse, you've got to have that. So the boards still have great deference from the courts. It's just not quite as good as it is in those zoning change cases. I wanted to mention Hudson versus Metro because there's kind of a new angle that's coming over the last 2 or 3 years, and this is mainly planning commissions. Most of the time, the planning commissions have adopted in their subdivision regulations that you've got to comply with the comprehensive plan or the general plan for the city or the county. A lot of times those plans are less concrete. They're aspirational in tone. They don't have the same specificity that the subregs, the subdivision regulations themselves have. The courts lately, and Hudson versus Metro may have been the first case, my partner Tom White was involved in it and we lost. The Metro Planning Commission had a subdivision in front of it. We felt like we had met, Tom felt like he'd met all the requirements, and the Planning Commission approved the subdivision. On appeal, the neighbors challenged that and said, listen, the board didn't really look at the general plan, and as a result, we think they didn't comply with some portions of the general plan. And ultimately, they won on that argument. So we may be seeing a little bit of a change on some of the issues, at least as far as the subdivisions go. Site plan's a little different, and the conditional use permits in front of the zoning board are a little bit different. But subdivisions, because of the impact of the general plans, it may be a little less clear what happens on those cases. Again, I'd say you want to be a little more careful in those situations, just because it's the courts do review them with a little bit more scrutiny, and it makes it a little bit easier to get reversed. You just want to bear that in mind when you're making a decision. I threw in the thing about potential legal liability on the members. That is very unusual.
Oh, I think Mr. Hasty has a
go ahead.
question here.
A unique case, I guess, probably about 25 years ago, a client of mine hired you, as a matter of fact.
Oh, okay.
We were in the city of Gallatin. We submitted a site plan. We met 100% of all requirements. We made sure going in. It was Flipper's Bait and Tackle Shop.
Oh,
I
yeah.
don't know if you remember it.
I do remember,
He
yeah.
had a small bait and tackle shop,
Mhm.
and he wanted to tear that down and build a new one. And Gallatin just flat turned it down. It was a expansion of a non-conforming use, and they said, you can't do that.
Yeah.
And I don't know what you did,
I-
but you sent them a letter, and they sent me a letter, said, resubmit it and we'll approve it.
Ah,
But-
okay. Well,
And I hope he paid you.
yeah, I remember. I'll keep my fingers crossed. Let me kind of talk about that with that question. From the standpoint of a zoning board, you've got, I think of them as three major powers. You've got the conditional use permit that we talked about. I keep bumping that speaker, the mic there. Conditional use permit that we talked about. Variances we'll talk about in a second. And then the third thing is reviewing decisions made by the local codes official, basically. Many times that means a non-conforming use. And in Tennessee, we have a statute that governs our non-conforming uses. I remember the name Flipper. I didn't even remember which way it came out, so I'm glad it came out okay. The statute is, and again, this is really a zoning board issue. First of all, it's extremely complicated. So if you get into a case, you want to have the city lawyer help you out with it, because it's, the statute's probably 5 pages long now. It's grown, was first adopted around 1973, I think, by the Tennessee General Assembly, and it's just kind of grown from there. It was very short and simple in the beginning, but it's very long. The general overview is, though, non-conforming use, what is that? A use that, my shorthand is a use that legally pre-exists the effective date of the zoning ordinance. So if you've got a land use that is already there before zoning hits it, or it's legal under the zoning that exists now, but we change the zoning while it's there in operation, then it's still legally non-conforming. You can become legally non-conforming in one of two ways. And a lot of people just call it grandfathered kind of use. In most cities most states across the country, that's as far as it goes. They want to stamp out non-conforming uses. And so if you've got a non-conforming use, they basically say you can't expand, you really can't, we don't want you even to fix the place up. We're committed to running the place down to the point that you're gonna have to stop and move, build someplace else, and become legal. In the early 70s, the Tennessee General Assembly looked at that and said, we don't like that idea. That's not so good. And so they passed statute 13-7-208. That's how often land use planning lawyers use it. I can rattle it right off the top. That statute was passed, and the general idea was this, the three major issues. If you have the non-conforming use, you can stay as long as you want. You can fix it up, you can do whatever you want. If you have a non-conforming use and you want to expand, you can expand the non-conforming use under the terms of the statute. Now, you cannot buy more property and expand on the added property. But if you had enough property there to begin with, you could expand. And I'll say this, it's not absolutely clear, but you can probably expand into the required setbacks. As long as you don't create a nuisance, the statute says you can expand your property, the land use. Third and finally, and you can do this, I don't think any other place in the country except Tennessee. If you think the building is just, you've outgrown the building and it's just not technologically up to date and you need to do something to keep your business rolling, you can tear it all down and start all over again. Apply for a new building permit and put up a whole new building as long as it's that non-conforming use. Now remember, everybody around you is doing something else. They can't do what you're doing. But the Tennessee General Assembly says you can tear the whole thing down and build a completely brand new building. You don't have to move someplace else. You can build a whole new building right there where you are. So it's a very powerful statute. a lot, probably Hendersonville probably has your regulations are probably up to date. I see many zoning regulations that don't even mention the state statute and basically say you can't expand a non-conforming use. You can't make any changes to it, and that's just wrong, because the Tennessee statute takes precedence. If the ordinance, the zoning ordinance, is contrary to the statute is effective and not the ordinance. So those three basic things, that you can stay, you can expand, you can tear it all down and start again. Non-conforming uses, and again, if you get a case from the zoning board, I don't think I've ever had one in front of the planning commission. But on a zoning board, they see these with some regularity. The question usually is, when did it start? Did it start before the zoning ordinance took effect? Is there enough proof to demonstrate that? Now, that's a fact question, and the zoning board gets to make whatever decision they make. You gotta have some evidence, but that's one of the important issues.
And George,
Yeah.
we run into this issue too, with signs.
Yeah.
Because signs also has the same kind of flexibility that the
Right.
state has given buildings.
Yeah.
It's also given quite a bit to signs. There's a little bit, it's not as clear
Yeah.
for signs as it is buildings. So it's not exactly the same thing,
I
but
got a call from
there's some flexibility.
from Laura Fox at Metro Legal, the legal department for the city of Nashville, 3 days ago, 4 days, maybe late last week, I guess. Exactly that question on sign, because she's got not a billboard now, just a business accessory sign. And she said, George, I don't think they've got the same amount of protection. I said, I think that's probably true, Laura, but take a look. I tried a case, again, a long time ago, in Williamson County, about an accessory sign on National Auto Truck Stops of America. In fact, if you're heading south out of Franklin on I-65 towards the state line, on the left-hand side, you'll pass it was that National Auto Truck Stops, and you'll see the big sign there. They all have the big sign. And Williamson County had adopted a zoning ordinance that would have amortized the sign, basically. The idea was to lower it and then get rid of it. And the problem is, amortization, as the name suggests, the idea is to give the non-conforming business, sign, whatever, a certain amount of time so that the owner can hopefully get compensated for whatever the cost of the sign or the building or whatever it might have been, so he can make some money. So maybe you give him 10, 15 years, and then you say, okay, after that, it's got to come down. The difficulty is with our statute here in Tennessee, you can't really do that because the statute says you can stay. So yeah, and so on accessory business signs, it's a hard kind of a thing. I don't know that I can give you any.
Where I think the staff has difficulty with it.
Yeah.
And where we struggle with is when you've got a sign, say we don't allow pole signs.
Mhm.
So you've got a pole sign over here on Main Street.
Yeah.
What has been historically what we've done and kind of what's in our ordinance is, okay, they can replace the guts out of it and they can maintain it,
Yeah.
but they can't
Replace the
they
structure.
can't
of upholstery.
replace the structure
Yeah.
and they can't replace the cabinet.
Yeah.
But then in looking at the state statute, I could see how it could be stretched to
Yeah. and
say,
it was-
well, they could actually replace the whole thing.
Yeah, in the Williamson
it's-
County case, again, of course, that business accessory sign on those auto truck stops of America, whatever they are kind of odd because they're designed as well. But part of the issue there was we took down the whole sign. We entirely replaced the sign, basically. In fact, they called me. The company called me during the litigation and said, "Hey, we think the sign's in bad shape and it's going to fall." I said, "Well, take the darn thing down. You don't want it to hit somebody. I mean, we'll figure out the litigation later. Take it down." And so, at the end, they wanted to replace the whole thing, and that's ultimately what the court upheld was total replacement. So let me say, in fact, I don't know how many of these I've argued, not signs. They're usually buildings, but when I argue in front of a judge about the nonconforming use statute, 137208, I usually start out by saying, Judge, this is a bad statute, because I think it's a bad statute. They're taking power from the local government to control these kinds of things that I think the local government should have. The problem is, the General Assembly, for whatever reason, well, there's a lot of sign interests who lobby on Capitol Hill. That's certainly part of it. And there's also just a kind of a streak that says, well, you know, by golly, if somebody's got that thing there, and they're usually thinking of a business, they ought to be able to keep that business. And yeah, I would agree with that. I don't think you ought to be able to take somebody's business that was there before the zoning started, but allowing the expansion and then a total replacement seems like it's going a little bit far. But I usually preface my argument with the courts about that I just think the statute as it's written is not a good thing. But it's so powerful, it's so strong, that it's very difficult to overcome it from the local government standpoint. It's a difficult thing. And it'd be worthwhile taking a look at that. If I could think about it, I'll find a copy of National Auto Truck Stops and send it to you. Because really, that was one of the issues there. It was how close is that to a protected structure under 137208. But again, the nonconforming uses fits into the discussion very well, because really it takes a lot of our discretion away from the local officials, because that statute is just so broad and protects the land use. Now,
Ty has a question.
yes, sorry.
On the
Can you turn
subdivision,
your mic on where it goes green up there, Ty? Awesome. Perfect, that's perfect.
is it on? Yeah. Okay. So going back to what you said, now, me not knowing anything about law, but you just stated the sign, the gentleman called you up and said, hey, I think this is going to fall down, it's a hazard.
Yeah.
And you said take it down. So doesn't that bleed into arguments could be made about safety? And safety hasn't been discussed here today, but it sounds like safety across the board could be used as a utility to get the work done you want done.
Well, generally, again, let's talk nonconforming use for a moment. Generally there, the reason I told him to take it down was just, I didn't want anybody to get hurt. But on the other hand, I also knew I was going to argue that under the statute, he could replace the whole thing anyway. So ultimately, we'd find out through the litigation where he was going to be. And ultimately, the company won, so the sign's up out there. Setting aside nonconforming uses for a minute and just talking, say, conditional use permits in front of the zoning board, safety is always one of those things that gets thrown in there, and the courts just won't accept it because it's too broad. If I'm coming to the board with an application, how do I ever prove that it's safe? I'll represent to the board that we're going to comply with the standard building code, international building code, I guess, these days. And yeah, there's not much more I can do. If there's a traffic study done, I'll have the traffic study. But the courts are looking for something much more specific than that. Now, at the level of the local legislative body, the city council, it can make decisions about those kinds of things. But at the administrative level, say zoning board and planning commission, those kinds of issues on what we're discussing now, site plan, plats, and conditional use permits, really don't help, and the courts are not likely to accept those as a good reason to turn down an application. It just makes it, that's why I'm saying you want to look for something very specific if you can find it in the record, whatever comes in front of you. Is if there's a traffic expert on the other side, if you've got two traffic experts, one saying one thing, one the other, then you can rely on whichever traffic expert you think makes the most sense. There may be other things like that. Sometimes property values, but again, not property values as articulated by lay people, because again, the issue is what's the property value in the future. Laypersons usually can't testify to that kind of thing. It takes an expert witness. I think usually what I do is I bring a an appraiser with me to testify about that value, because that's what they're trained to do, is say what the value may be in the future. Just relying on those broad kinds of things, public health, safety, general welfare, again, are okay at the zoning change level, the local legislative body, but in front of the Board of Zoning Appeals or the Planning Commission, it won't be looked at very satisfactorily by the judge. The judge will just ignore that. So it's not, I understand what you're talking about. The idea really is that the local legislative body, when they said that this daycare center in a residential area, when they said the daycare center could go in there in that general vicinity, that the idea is that they said it would be safe in those kinds of areas if they met whatever specific requirements were set by the local legislative body at that time. So those broad general things, again, public welfare, safety, public health, at the administrative level just don't work very well. I wish I could tell you something better about that, but that's just the way it works. Let me hit one other thing from a Board of Zoning Appeals standpoint, variances. We're talking about conditional use permits with the board. There, again, you have to be a little careful from my standpoint, because the courts are going to look at it a little more carefully. Variances, because of the way the variance statute is written here in Tennessee, basically the board has a lot of discretion. And I don't know, does the local ordinance track the TCA very carefully, do you think? I don't.
Yes.
I probably should have looked, but
No,
I didn't think about it.
it does. With our variances, it's tracking that very well.
This is, there's two statutes in Tennessee. 13-7-109 is for the county. 13-7-207 is for cities like Hendersonville. They both read, I think, virtually identically. Where by reason of exceptional narrowness, number one up there, shallowness, shape, at the time of the enactment of the zoning ordinance, and exceptional topographic conditions or other extraordinary and exceptional situation or condition of the property, the board can grant a variance, and there's some other magic language too. But I like to emphasize these 5 points. And when I represented Metro years ago, the way I would start my argument, I don't know how many variance cases I've argued over the years. Most of them probably with Metro, because what happens is Metro would turn down a variance. And the property owner would feel like, wait a minute, you can't do that to me. This is my property. I ought to be able to use it the way I want. Well, no, you've got some kind of a violation. They've proposed to build the building. It's a 10-foot side yard, and he wants to encroach by 5 feet or something. And the board turns him down. Well, the board can't be beat. I mean, it's just impossible. Because even if you could show, let's assume that we've got the applicant, he wants to build within 5 feet of the property line, and the side yard setback is 10 feet or something. Board turns him down. Even if he can show that the property is exceptionally narrow, the other properties in the general vicinity are very narrow. The way the statute reads, it gives the board so much discretion about whether that's really a hardship under the circumstances that the board can turn it down and really not ever worry about it. The most difficult part from the board standpoint is granting the variances, because it's hard to find one of these 5 factors, frankly. The applicant's supposed to show exceptional narrowness, exceptional shallowness, exceptional shape, some exceptional topographic condition, there's a cliff or there's a stream running through the property, something, or some other extraordinary and exceptional situation or condition of the property. And I've got members of the zoning board here. I've been in front of zoning boards I don't know how many millions of times. And it always seems to me most of the folks who show up in front of the zoning boards never mention any of these things. Now, I hope your experience is different and people actually talk about some of this, but most of the time when I'm at the zoning board, and I'm just listening to the other cases now, nobody ever mentions these things. The mother-in-law needs you know, a little place to live, and we need to build a little house out back or something,
And
put on
yeah.
a mobile home. There's usually some personal reason why the applicant is there, and I can understand that. And I'm not saying I'm not sympathetic. A lot of times, I'm very sympathetic to it. But it's harder to justify because the statute makes it difficult for the board to grant the variance.
And George, what we've done is with our ADUs, with accessory dwelling
Yeah,
units.
right.
Those have to be somewhat family-related or a special exception. And then the way we handle those is, it's not a variance.
Yeah,
It's
that's
a
the way to do
It's
it.
a conditional use.
Right.
And then that way, there's got more ability to consider some of those personal
Yeah,
things.
that's exactly right. In fact, I was going to mention at the end here, the way to do those things is exactly the way you're doing it. Make it a
Yeah.
conditional use or some other technique, but conditional use is the one that
And
stands out.
And we do that as well, I think, with like metal on buildings. So like metal on buildings
Right.
and things like that, we do it. And on variances, probably 8 out of 10 variances that go before the BZA don't strictly meet all of the requirements we
Right.
have in the zoning ordinance. And we explain that to folks before they submit, and a lot of those end up getting turned down. But since sometimes I think what happens is, it doesn't clearly meet those things.
Right.
But if there's a little bit of something
Right.
that the BZA can grab a hold of, and the adjacent property owners
Right.
are okay with it, then it may have a chance. But I think
That's
our
100%.
Yeah,
Yeah,
our BZA on these side yard, especially these side yard variances, it really has a lot to do with the adjacent property
Property owner.
owners. And they're real sensitive to,
Yeah.
we don't want to create a problem for adjacent owner.
Right.
Just so you can use more of your yard.
Yeah.
Is kind of what happens.
Well, and in fact, that's excellent, because from my standpoint, that's really, I mean, you could still wind up maybe having some kind of little difficulty, but that makes the most sense to me, because the statute is so hard. There was there's something called the Standard State Zoning Enabling Act that was promulgated by the Department of Commerce. Herbert Hoover was the Secretary of Commerce back then, the 20s, maybe even the teens. It had a very benign general standard for variances. In fact, when Memphis adopted zoning in, I think it was 1922, probably the first city in the state to adopt it with a private act, not through what we use today, the public acts. Memphis used the old Standard State Zoning Enabling language, and it has no standards, basically. You can grant a variance for any reason you want. Some of the old variance cases are from Memphis, where there was no standard, and so the court said, well, I guess they could do anything they wanted. Let them do it. As a result, in 1935, when our version that we use today was adopted by the Tennessee General Assembly, they wrote it a little bit more strictly. And to my way of thinking, maybe maybe they went a little bit too far the other way, because it's really hard to legitimately get a variance. And so I think many people do exactly what you said. If the property owner next door doesn't have a real problem, and if they come close to meeting something, we'll try and help them out. I will say, again, if you're turning one down, not much to worry about, because in that instance, the zoning board has a tremendous amount of discretion. And really, when you grant a variance, the courts want to find a way to uphold it. It's just a little bit more difficult because of the statutory requirements. And I thought I'd put in the.
And George, one thing you skipped over there was
Yeah.
the personal liability.
Yeah,
I wanna make sure
let me say, I kind of, people worry about that all the time. And really, it would be extremely difficult for anybody. I mean, if you intentionally did something that was totally inappropriate, I guess there could possibly be some, but it is very difficult to, a member of the Board of Zoning Appeals, a member of the Planning Commission, a member of the local legislative body, very difficult to hit one. I can't think of a case involving a board member, certainly in Tennessee. I don't know really outside, even in other states. Codes officials in Tennessee have the possibility, I know that folks in the back don't feel too good about that. Was it Steve Mills who was the building code official here for years? Yeah, Steve and I went way back. And, and the building code officials especially are always worried about this stuff. But even them, there's one case involving a codes enforcement official out of Memphis, maybe 5 to 10 years now back. But most of the rest of the folks, especially members of the zoning board, planning commission, there's something called the Tennessee Governmental Tort Liability Act, which really protects you, and it would take something really, I mean, you don't want to do something wrong, and certainly you don't want to do intentionally anything that's wrong, but there's not much by way of legal liability out there.
George, can I mention something?
Yeah,
If somebody sues y'all individually for your work for the city, we're gonna defend you. And it's something that I promise the board members, it's something I promise planning commission, something I've promised all our commissions and boards. If for some reason somebody decides they should sue you individually for something you did up here, we're gonna defend you.
and there'll be, in all probability, a motion to dismiss, because again, a motion to dismiss is a preliminary, you don't get to a trial usually, because the statute, the Tennessee Governmental Tort Liability Act, really is very protective, particularly of people like yourselves who donate their time to the city, trying to help out. The state of Tennessee, the local city, nobody wants to see folks like you are donating your time being caught in any kind of thing like that, so.
It routinely happens that when the suits come down, the individuals are shotgunned in with the whole lawsuit. And the first thing that happens, the defense attorney goes in and says, we want to dismiss all of these individuals because of agency, the lawsuit falls back to the entity.
Yeah,
That's under the Tort Liability Act.
okay,
And,
well,
that's
there's an express provision, basically says you just got no liability, essentially. I mean, it's.
exactly.
Now, there's some federal rules, the Federal Civil Rights Act is potentially applicable in some situations, but I can't really even think of how you all could be in that. And let me also say, the old style, when I first started practicing law, what they used to do is, there's something called a common law writ of certiorari. This is a type of lawsuit where you're appealing a decision of a zoning board and a planning commission. They're not, most cases involve a common law writ, involve zoning issues, zoning board, planning commission. In the old days, when I first started practicing, they would name everybody on the zoning board, name everybody on the planning commission. The idea was the planning commission and the zoning board really don't exist outside of the city, so they'd name everybody, and I guess they would serve everybody. I hasten to add, though, they didn't ask for money. All they wanted to do was get a reversal of the decision made by the body. So you could get served, and from time to time, I guess I've seen it these days. About 20 years ago, 25 years ago, I started, I never used that myself, but I started, because of the same problem, instead of, I sue the city, say, if I were going to appeal a decision of the zoning board here, I would name the city of Hendersonville acting by and through the Board of Zoning Appeals. So none of the members of the zoning board would be implicated in any way. And again, although in the old days they used to name the folks, there was no monetary amount requested. It was just, we're trying to get the subdivision plat approved or the conditional use permit approved or whatever it was.
And George, I think what happens on that is, it's just that threat of a lawsuit.
Sure, yeah.
And then they it's like, well, we may sue, and then we're gonna name everybody that voted against that or for it,
Well,
And that's kind of, it's usually just kind of a threat.
The main takeaway is, that's really laughable. I can't even think of a situation, Bill Terry, I had to name Bill, he was, what was it, which city? Oh, shoot, oh, well, I can't remember. Anyway, it's close to here, I can't remember it. Had to name Bill as a result for something called a mandamus. In the situation of a mandamus, you have to name the individual who actually issues the permit or whatever. So I named Bill. And to this day, I'll see Bill at a meeting or something, and I'll say, yeah, I'm the only guy he ever sued personally. I said, well, no, I didn't sue you personally. I wasn't asking for money, I just needed to get the permit, you know? And I can't think of another way, in my experience, don't get me wrong, I'm sure when I was back at Metro, that we had, actually, I'm not even sure of that. I can't think of a case against members of boards. Believe me, codes officials, yes, that happens. Those folks are usually very well protected as well. So it's really an empty threat to talk about. They can appeal your decision up to the courts, but I guess I should, so I suppose in the context of, say, telecommunications, you got the Federal Telecommunications Act, they're putting a tower up. That limits your discretion. I didn't talk about that in here. If you're involved in one of those, usually a zoning board issue, you want to listen to John about what you can do and what you can't do, because there's a federal law that restricts your discretion there. But again, you just follow the law, you're in pretty good shape. But as a matter of getting sued under Tennessee law or anything else under federal, just very, very difficult to do.
George?
Yeah.
I was going to say, I know a lot of the TML trainings that we've had, I've had over the years, a lot of times one of the things they preach is basically government tort liability covers you, but if there's negligence, of course, you know, negligence is one of those wide words that people want to use. That's one of the things, because they're an insurance provider, you know, they're trying to make sure that you don't, do anything that could be considered negligence.
Well, and I
Are you aware of anything like that? Well, the post officials and stuff like that, you're saying?
certainly, one of the reasons to have these kinds of little discussions is to try to give you the best idea of how to approach the decision-making process. But regarding negligence, the Tort Liability Act, what it did essentially is it said in certain kinds of things, car accidents being one of the biggest, slip and falls another, certain kinds of things like those, the local government can be sued. Before that, there was a real issue. I won't get into the historical analysis, but before that, there were some issues about it. Under the Tort Liability Act, they said, okay, if you have negligence in, you left a banana peel on the floor and somebody walked or slipped and tripped and broke their neck kind of thing, the city can be held liable for that kind of action. That's negligence. Same thing with a car accident. If you're a codes official driving the car and you have an accident and it was your fault, okay, the city can be sued for that. But the rest of the statute basically says for everything else, there is no liability. And then for folks like you all who sit on boards and commissions, there's kind of an extra special dollop of protection. So it's really hard to reach. And I wouldn't say negligence, because if you were liable for negligence, yeah, you get sued all the time probably. But you're not. I mean, it's got to be something a lot more than that in order to get to you. And like I say, I can't think of a situation. I've been practicing 43 years. I can't think of a situation in which anybody's been sued, any member of a board or commission. That's not to say it hasn't happened. It may have happened, and I just wasn't aware of it. But I can't think of a case where it's happened. And I'm positive that no zoning board member or planning commission member arising out of their duties has been held liable. I mean, that's just, it would be almost inconceivable to me. Now, again, I guess, all kinds of things can happen, and you should never say it's impossible, but very, very unlikely. Even in the codes context, the case that I was thinking about is an inspection case where the inspector went out. It was a church. Church was in pretty bad shape. He wrote up a report, said that the roof to wall connection was kind of shaky. Things didn't look too good, but it was a church. They went to him hat in hand, said, listen, we're trying to raise some money. We want to get it fixed up. This continued for several years. Finally, the pastor and his wife and 3 kids were parked in the minivan immediately adjacent to the church. The wall did collapse, killed the 3 kids and the wife. The pastor survived. lawsuit back against the city and the inspector. Inspector was terminated, and the city was held liable for that series of events. I frankly still think it fits within the scope of the exemption in the statute, but you can see where that kind of an aggravated set of facts, and it reached, as I recall, got up to the Tennessee Supreme Court, and they upheld the decision against the city. But again, most of the kinds of things that you see on in the codes area are other kinds of things. Usually they're federal issues where the federal Fourth Amendment limits inspections. And so sometimes you have inspectors get a little enthusiastic and do inspections where they probably can't. And you see some of that. But again, you all would not be involved in anything like that, so really not a problem. Sorry, I wander on. I've been through this so many times that whoops. Oh, there's the variance case, Coble versus Greene County. Just real quickly, Coble or Cobble, whatever it is. This is fairly recent. The decision denied the variance. There was some topographic irregularity on the property. The difficulty was, and I think it was a side yard variance of some type, carport, something. The difficulty was that the topographic problem, the irregularity, the hills or something, as you might expect, didn't affect just the one property, it affected the whole neighborhood. Excuse me, and the Court of Appeals said, well, listen, if everybody suffers from the same hardship, then we shouldn't be granting variances. You ought to change the zoning to allow a little bit easier time for everybody, and so they reversed the decision. That's probably the leading case these days, but again, the way you're handling these cases sounds to me like you're in pretty darn good shape with those. Variance cases, again, much more discretion. I'll talk a little bit about vested rights. I don't know how often this comes up. There's two statutes, again, much like the statutes for zoning and variances here in Tennessee. 13-3-413B through K is for counties, and the other one up there, 13-4-310, is for cities. As many of you may know, before the statute, I think it was passed in 2014, really kind of took effect in 2015. The idea was that there really wasn't much protection for someone who got a building permit and even began construction. What could happen is that if the local legislative body decided that they wanted to change the zoning, they could change the zoning, and if it was done before the person who pulled the permit got to whatever substantial construction is, then the permit could be revoked. Now, most cities, frankly, didn't play like that, and most of the time, if there was a zoning change and you had your permit and you were doing work, most cities would let you go forward. But there were a number of cases where that didn't happen, and so ultimately the Vested Rights Bill got passed. And again, the old rule before 2015 was that you essentially had to have a building permit plus substantial construction, and in almost all of the reported cases, you could never get to substantial construction. Nobody knew what it was, and two, it was almost impossible. You couldn't get there because what did you need to show substantial construction? If you had the framing up, is that substantial? I don't know. Tom White, my partner, had a case in Davidson County where they had gotten a significant amount of the infrastructure in before getting any building permits. This is a subdivision, and had put in the water lines, and the zoning changed, and he wound up losing that case. It's a hard. It was a hard rule back then. The vested rights these days is a little bit easier. What they were trying to do is make it objective. So the term substantial construction is so difficult to understand that it's not easily enforced or administered. So they basically wanted to make it a little bit more concrete about what would happen. So the idea here is, and you can read the thing, during the vesting period, the locally adopted development standards, which are in effect on the date of approval of a development plan or building permit, shall remain the development standards applicable to the property during the vesting period. And usually there are two or three, it's kind of a 2 or 3 step process. Generally speaking, if the development is one which requires some kind of preliminary approval, say preliminary plat from a planning commission, the protection starts on the date of the approval of the preliminary plat. And I always have to look at the statute, so don't take this as the gospel. This is my rendition of the numbers. After approval of the preliminary plat, the applicant's got 3 years to get final approval of the plat. So I gotta go back to the planning commission to get the final approval done. Got to get whatever permits are required. I take it in the context of a subdivision, that does not necessarily have to be the building permits, but might be for site preparation. If you need a permit to move the earth around out on the site, that may be enough to get you to the next step. So you got to get final approval, got to get whatever permits are involved, and there's a third one, I'm missing it. Oh well, but you've got to get those 3, you've got to get them within 3 years after approval of the preliminary plat. Then you've got to get into you've got to begin site preparation. So permit, get the permits, get final approval, and begin site prep within 3 years. In the next 2 years, you've got to begin construction. And then you've got, assuming you've begun construction within those first 5 years, you get 5 more years to get the project completed. In addition, the city can always grant more time if it seems appropriate. So it's kind of a 10-year process. For a single-phase development, for multi-phase developments, it goes up to 15, and again, the city can always grant more time if it feels it's appropriate. There's also a separate set of requirements for building permits, and essentially that turns on the frame of time that you've gotten in the building permit. I don't know, seems like most departments are issuing permits for 180 days or a year maybe, and usually you can go in and get it renewed. But that's the statute talks about the length of time that's actually specified on the permit with regard to building permits that stand alone. So you've got a piece of property that was subdivided years ago, but it's never been developed, it's just raw land, and you want to build a home on it, you go get the building permit. Whatever Hendersonville's typical length of time is, you're vested during that period of time with the development standards that were applicable at the time that the permit was issued. Just to give you some idea of some of the problems that can come up, Neighbors of Old Hickory versus Metro Nashville is a case that Tom and I tried 4 or 5 years ago. And this is the one, the Hendersonville versus Allen, the vacation rental case. Same judge decided both of these cases, the Neighbors of Old Hickory versus Metro Nashville. And what happened in this case is that Tom and I were representing one of those things that everybody loves to have in their neighborhood, a rock quarry. That's always one of those things that the neighbors love to have. Now, the property was zoned heavy industrial. Tom and I, our client came to us, said, you know, we've identified a spot, we think it's good to go, take a look at it, what do we need to do? Tom and I took a look at it, and essentially the idea was, well, you know, we need to lay the groundwork because what's going to happen, most likely, and hard to blame anybody, as soon as we apply for a permit for a rock quarry, people are going to be coming out of the woodwork and opposing it. Notwithstanding the fact that it was permitted by right in the heavy industrial district. So we tried to get everything lined up as best we could at Metro Codes. We go in and apply for the permit. Metro at the time, and in a way, very fortunately, although we didn't recognize it at the time, had a requirement that you have a development plan approved, but wasn't a site plan, which would normally go to the planning commission. It was just a development plan from their standpoint, which gets approved by one of the codes folks there at Metro. So it takes us 4 or 5 months to get the permit and the development plan approved, but ultimately, we get both of them approved. And within this time, the neighbors have contacted the local councilman. Councilman files a bill in the Metro Council to change the zoning. Now, remember, until we get the building permit and/or the development plan approved, we don't have anything. I mean, you know, if the zoning gets approved before we get the building permit or the development plan approved, we don't have any vested rights. The vested rights statute requires you to have the development plan or the building permit in order to get approved, or in order to be vested. Ultimately, the zoning ordinance changing the zoning on the property does not get passed until about 2 or 3 months after we finally get the building permit and the development plan. The neighbors wind up suing us anyway, and we wind up in court over it. The case actually went to the Tennessee Court of Appeals as well after the trial court's decision. I'm assuming that the local, I can't remember now, but I'm assuming that the local judges recused themselves with the level of neighborhood opposition. You know, the judges run for election themselves. Easier to recuse yourself and have somebody else come in. And so, I can't quite remember the judge who tried the case. Ultimately, he holds that we did have vested rights, that the development plan was approved, the building permit issued before the zoning change took effect. And the argument on the other side really was that we had to have something more than that and had to show that we were substantially done with the project. Well, of course, that was true under the old law, but under the new law, that's not necessarily the case. And, you know, I'm not sure how you show substantial construction of a rock quarry anyway, because you're not really constructing anything other than maybe the way station and some office facilities. Trial court rules in our favor, case gets appealed. And the interesting thing about it, to me at least, is one of the reasons I bring it up, is that the Court of Appeals took a look at it, and Tom and I really didn't even hit our radar. The Court of Appeals said, wait a minute, the building permit was for an office and for the way station. You know, that's an accessory to the rock quarry, but not the rock quarry itself. So the building permit doesn't really give you anything. You got to build. Yeah, you're vested to have an office, but that's not going to do you much good if you don't have the rock quarry to go with it. But the rock quarry wasn't part of the building permit. There's no construct. You don't build a rock quarry. So the building permit really doesn't help you guys. So I thought, uh-oh, that's not good. Fortunately, and again, we probably wouldn't have asked for this development plan to be approved because we didn't recognize the distinction that the Court of Appeals brought out. But fortunately, Metro Codes had required us to submit this development plan. The Codes Administration had signed off on it. A friend of mine at Codes actually happened to be the reviewer. I didn't know he was doing it actually at the time, but he signed off on the plan and approved it. So we had the approved plan, and it turned out that that's what hooked us into the statute, that the building permit itself would not have vested our rights. The only way we won really was on that development plan that was approved by Metro Nashville before the effective date of the zoning change, which took place several months later. So if you're looking at, and let me also say, like the non-conforming use statute, if you're involved with one of these vested rights statutes, you want to rely on John Bradley. It's a complicated statute. There was a lot of negotiations on it at the final minutes of when the Tennessee General Assembly adopted it. It's a little vague in areas, so having a lawyer take a look at it and try to help, it's helpful to have that kind of counsel.
And George, let
Yeah,
me
go
just
ahead.
share one thing for
Sure.
the planning commissioners, is so like the Old Town Residential, where that was changed with, on some of the stuff George was talking about earlier. So with that change being had, there's nothing in the pipeline to get approved or anything, so, you know, what the ordinance is now is what the ordinance is now. Also, next year, you know, after hopefully we eventually adopt and come to the determination of the Westlake redevelopment plan, then that'll set up for next year for us to do that very large rezoning of all of Westlake, which is West Main Street and Old Town. And then once that rezoning's done and it's properly done and it's well supported with the future land use plan that we're going to have underneath of it, then once that's done, any projects that haven't submitted or went through the process, they'll have to abide by that new zoning ordinance. And so just kind of wanted to share that with you all, because that's something we will be dealing with next year. And we'll run into some situations where the city has rezoned property, not because anybody asked for it, but we've rezoned property. And we'll have some folks be like, well, hey, wait a minute, you know, I want to do this. Well, once it's changed, it's changed. As long as we go through the proper process in doing that change, then, you know, you can see, as George stated, it's pretty locked in on what that requirement is. Okay.
In
Thank you,
fact,
George.
the vested rights statute doesn't preclude you from changing the zoning, even if the owner has vested rights. It just allows the owner to continue on with whatever project he had, assuming that he does it the right way. But yeah, if you change the zoning before any kind of project's gotten any kind of preliminary approval, then that's going. What was really happening, what caused the adoption of the vested rights statute was these situations where the fellow would come in, get the building permit, begin work on the project, the zoning would change, and then the city would revoke the permit. The developer would file the lawsuit and argue that he was entitled to vested rights based on the building permit. But the building permit alone, under Tennessee common law, before the vested rights statute, did not guarantee an ability to complete the project. You had to have a building permit plus that substantial construction. And again, I argued, I don't know how many of those cases. Well, I tried not to argue them because they're very difficult to win. I think between Tom and I don't know how many we argued. The only one I know that we won was one that I won accidentally, really. It was a mobile home. And as soon as we moved the mobile home on, we said, hey, we got substantial construction. And the local judge figured that was okay. So, but most of the regular kinds of stick-built housing or commercial or industrial, you just can't get to substantial construction. And so the statute came in. And really the case, I've forgotten the case, it was out of Nolensville, that really tipped it off. It was a project that had been going on for some time. They were like in the phase 5, and they wanted to continue using the same standards for the roadways. The city had changed their standards to up them some. Jim Murphy, old friend, tried the case for the developer, arguing that the first 4 phases should be substantial construction. And the court said, no, you're talking about phase 5. You haven't gotten anywhere on phase 5. And so they've changed the rules on you. You're stuck. And so Jim lost the case. The General Assembly picked it up. But I still would say, you know, over in phase 5, I don't know, you usually have to be 15 years. That project may have taken longer than 15 years. The city, even with the statute, may have been able to change the rules to improve the road standards if you take that long. You know, once you get out beyond 15 years, the vested rights statute doesn't really protect you anymore unless the city agrees. Anyway, so it's a good statute. It's a little complicated. They're trying to do something that's helpful. There is the question, because you have to get a development plan approved or a building permit, and it can take a little while to get those, you still have the problem from the developer standpoint that a zoning change can be filed, and you may be able to get a zoning change through before a building permit is approved or the development plan is approved. And again, the fellow trying to get the project underway doesn't have any vested rights unless he's got one of those two things.
And what we do, George, as the planning staff, is it's up to the applicant to assert their vested rights, not for
Sure.
the planning staff. Same thing with, we don't talk about today, but religious exemption, we don't assert that on behalf of the applicant. They'll need to assert that. And then also with agricultural exemption, that's something for the applicant to assert. We're not going to say, oh, this fits into that. They'll need to assert that for us to do that.
Yeah. And no problem with any of that. That's certainly appropriate. And one of the other things I wanted to mention along those lines, some of the cities are trying to, and you may be doing something like this, trying to limit the number of isolated zoning changes they have. Remember, the developer who gets the building permit or development plan approved gets vested, and the standards that were in effect at that time now govern his project. As the years go by, you may change the building code, you may change the subdivision regulations, you'll change the zoning ordinance. If you try to limit the number of, the reason I say this is Metro Nashville makes 20 or more changes to the zoning maps and the text every time they meet, every 2 weeks. So it's a real problem there. But if you can limit the number of those kinds of text changes, especially to once or twice a year, then if you're looking back 3 years, you may have a better chance of figuring out what really applies to this particular project, because trying to keep track of which standards were applicable, 3 years ago can sometimes be a little tricky. It depends on the number of ordinances you're talking about and the number of changes. So Franklin, I was talking to one of the city administrators in Franklin, and they were saying they're trying to do that. They're not as successful as they'd like, but they're trying to just do a single update to the zoning code once a year. As far as text goes, of course, you could change the zoning map probably, and it wouldn't have too much difficulty. Those are pretty easy to keep up with. But text changes are a little harder to administer and enforce. And again, like I say, in Metro, they change them willy-nilly, so it's really hard to figure out what's going on. I'll move on from the vested rights and hit, whoops, went one too far there. We mentioned Hendersonville versus Allen. I won't go back to that. Keith just mentioned agricultural, and I put this in before I realized we're talking to a city, and so the statute doesn't really apply. But I'll just mention it because I think it's a fun case anyway. And Sam may have mentioned this. If he did, just call me off. Jefferson County versus Wilmouth. There is an agricultural exemption statute for cities. I've forgotten the number, the statute number. It is not as effective as the county one, however. Basically, it says that any agricultural use that was in effect at some point in time in the past, I don't remember when it is, it goes back 20 years, can continue. So if you're in a city and you had a farm, and you can prove that, then you can keep farming essentially. It's kind of like a non-conforming use, I guess. The state statute for counties, though, basically says that the counties can't regulate agricultural uses of land, essentially. And the question becomes, what is an agricultural use of land? And our farmers have gotten very creative, and I represent a number of them that are involved in this, and it's the wedding chapel issue. They're having little get-togethers, parties, weddings, wedding receptions out on the farm property. Wilmouth is just such a case. Over in Jefferson County, I've forgotten how big the farm was. It wasn't that big, 20, 25 acres or so. And the question always is, how is the wedding reception really related to agricultural uses of land? And again, I apologize because this probably doesn't, you guys probably don't see this very often, but I like this case.
George, we had one.
Okay, well, Wilmouth has kind of helped the farmers, basically. It's at least clarified the issues a little bit. And I'll just read the final paragraph. By the way, there's been a series of cases, really. A case out of well, I don't even remember the name, it's Shore versus Maple Lane Farms, I think it was called. That was one where the farmer was doing all kinds of things, helicopter rides, large concerts, just all kinds of things. He eventually scaled back on the helicopter rides and justified the concerts and things as entertainment related to agriculture. Well, the Supreme Court took a look at it and said, we think that's like a step too far, and overturned the result. The Tennessee General Assembly very, very quickly amended the statute to define agriculture, basically to include entertainment and education specifically. There hadn't been much of a definition of agriculture until that point. Again, this probably goes back maybe 10 years. Shore versus Maple Lane Farms comes down, then the General Assembly modifies the definition, and I'll just read the one about entertainment. Entertainment activities conducted in conjunction with, but secondary to, commercial production of farm products and nursery stock, when such activities occur on land used for commercial production of farm products and nursery stock, is an agricultural use of land. This is, I can give you the code, but that's probably irrelevant to you right now. And so we've got a farmer who's having weddings out and wedding receptions out on his property. And I'm just going to read like the final paragraph. The number of cases coming up under this rubric. The entertainment at issue, farm weddings, is necessarily conducted in conjunction with the production and operation of the farm. Mr. Wilmoth testified that the event venue is successful due to the aesthetic appearance of the farm and the farming operation itself, noting that the venue provides multiple photographic opportunities of general life on the farm. The record reflects that in 2019, the farming income amounted to approximately $6,250, while the farm rental income amounted to $47,247 in rental income for weddings and other events on the property. So, just by way of summary, $6,200 farming, $47,000 from rental for the weddings. Mr. Wilmoth testified in depth concerning his time spent operating the farm in comparison to the minimal time he spent facilitating his event venue business, which housed 5 weddings in 2019. Obviously, if he did 5 weddings and made $47,000, this is a lucrative business. We, like the trial court, believe that the present use of the property is in keeping with the legislature's obvious intent to allow the necessary supplementation of farming income with income from related activities, as long as such activities are secondary to the commercial production of farm products and nursery stock. Therefore, we agree with the trial court who dismissed the lawsuit trying to stop the weddings. So Wilmoth is the first case. I forgot when it was decided 3, 4, 5 years ago. And with the new definitions, nobody really knew how they would apply. Wilmoth kind of gives us an idea that as long as the farmer is spending more time farming, making less money, but it has the wedding facilities and spending less time on those, but making more money, he's probably okay. Probably also helps to be, Mr. Wilmoth was probably pretty a good witness on the witness stand probably as well. So interesting case. The farmer winds up winning there. When I represent the farmers, one of the things I do is I look back. There's a census of agriculture that the USDA puts out, I guess, every year. And it tracks the number of farms in every state. And it's pretty amazing if you start looking back 20 years and coming forward, the number of farms in Tennessee that are gone. We're losing farms right and left. And it looks to me, I'm not really an expert, obviously, but they track the farms by amount of income. It's just amazing how just not many large farms around anymore. The smaller farms, 20 acres or so, also having similar problems. So you can understand where the General Assembly is coming from, but it is kind of when that exemption for agricultural activities in the county zoning legislation was passed in 1935. it was thought at the time, there's a little book out that discusses some of this. It was thought at the time that the agricultural exemption was a giant loophole that could allow almost anything. And I don't know whether that's quite true, but certainly it can, the agricultural exemption can be used for a lot of things that you wouldn't necessarily think of as agriculture. And I grew up on a farm. My father's a nurseryman. My father and brother run the farm still. So I'm pretty sympathetic to their point, but at the same time, I always think, wow, you know, that's a broad exemption. And the folks who live nearby the farms that have these weddings and receptions may pay a little bit of a price for, by way of traffic and other kinds of concerns that occur on the property. Anyway, just an interesting area. I didn't realize until this morning, I thought, well, wait a minute, Wilmouth is really a county situation, and there's not, was it an agricultural definition here at the, under the Hendersonville?
So Ron Shalasta, who has a farm out, this is when we had the planning region.
Oh, yeah.
He
Okay.
had some problems with a neighbor who was having some concerts, but he was having weddings. So we ended up having some conversations, and everything worked out okay.
That's yeah, hard to complain if you've got, you know, don't throw stones at glass houses kind of thing. Finally, I'll just mention, we got 5 minutes left, Lund versus Dixon County. This is a case that's a little bit like the maybe variance cases and nonconforming issues, in that you've got, it's a testament to the discretion of the zoning board. It's a zoning board case. Again, planning commission similar in a situation interpreting the provisions of the subdivision regulations. This case involves that third area that we were talking about. Zoning board can grant conditional use permits, grant variances, and then it can review decisions of the local zoning administrator or codes official. Non-conforming uses are often one of those. Another thing that happens is that the codes official makes a determination about what is an appropriate definition for a term in the zoning ordinance. This is a set of oil tanks out in Dixon County. Tom and I represented a large oil company. Again, the zoning was appropriate on the property, zoned for heavy industrial use. We went to the zoning administrator along with our engineers and talked to him about, you know, did we fit within the definition of storage tank for purposes of being able to store petroleum products. And he made the determination that we fit within the definition. I won't get into the language of the zoning ordinance. There were some things that helped us very much in the way it was written, and it all it was put together in a way that made perfect sense, really. But some of the neighbors disagreed with the interpretation. They filed a lawsuit. Well, I'm sorry. They asked that the Board of Zoning Appeals hear the case to determine whether the codes official made the right interpretation of a storage tank. And so we went to the Board of Zoning Appeals. Fairly significant hearing, I don't know, 3 or 4 hours, a bunch of people testified. And ultimately, the Board of Zoning Appeals upheld the codes director's interpretation in our favor and said that we could go forward. The neighbors then appealed that case, that decision by the Board of Zoning Appeals, up to Chancery Court over in Dixon County. The chancellor ruled in our favor. We just got a decision from the Tennessee Court of Appeals, also upholding everything. The real point here is that this is another one of those areas where the zoning board has very large discretion. This interpretation of the zoning ordinance is, you know, unless the board and the codes official is just way out there, you know, kind of out of the ballpark somewhere, most of the time the judges want to uphold the decision of the board when they're interpreting the language of the zoning ordinance. So in this case, storage tank and how that's applied and used in Dixon County as a part of the zoning ordinance that's ultimately the decision of the Board of Zoning Appeals. The courts will get it and look at it, but all they're doing is saying, well, you know, if they interpreted it so broadly or so incorrectly that it's just perfectly self-evident that anybody can see that it was wrong, then we'll step in. But as long as it's reasonable, it's going to be okay, and we're going to affirm the decision of the Board of Zoning Appeals. Same thing is true over on the Planning Commission side. You don't see actual interpretations very often of the of the subdivision regulations, at least in the cases I'm involved in, I don't very often. But the Planning Commission certainly can interpret, and probably just as a matter of course in dealing with subdivision applications, there are interpretations that get made. And again, the courts are going to defer to both groups, both the Zoning Board and the Planning Commission, in their respective areas of expertise, because again, the courts are going to think that it's more important to have the local officials make this final decision and accede to whatever the local folks think is right, unless it just misses the boat by a wide margin, and frankly, that doesn't happen very often. So Lund versus Dixon County just stands for the proposition, again, that the local decision-making process ordinarily is going to be upheld by the courthouse. In fact, most of the time, there's really no reason to appeal. This was a case, frankly, I really didn't understand why the appeal was taken. It's a very long shot on the part of the neighbors here. Now, I will say the other thing, suppose the codes official had ruled against us, probably the same thing in our situation. If the codes official had said that, no, I don't think the ordinance that's sufficiently broad that it covers you, I think you have to approach it as a conditional use permit and go to the board for conditional use. I think we would have had to go to the board as a conditional use. And I think that assuming that the zoning board upheld that interpretation, the courts would have upheld it the other way as well, because it was one of those cases that could have gone either way. And the court would have accepted either decision by the Board of Zoning Appeals. And I've talked a long time. I'm glad to answer any questions if anybody's got any. My wife always said, "Why do you do this? This stuff seems really boring." In fact, I was at I was arguing a case in front of a circuit court judge in Nashville, again, a long time back. I've forgotten who it is now, who it was. And it was a Friday afternoon. They do those mock court things for the high schools in Davidson County. I'm sure they do it up here as well. And they bring them to the courthouse, and they have their final arguments, and they get a bunch of lawyers come in and act as judges. And well, these guys, these young men and women from one of the high schools had come in on Friday afternoon. The arguments were the next day for the mock trial stuff. And the teacher pokes her head in and sees us. We're, look official. The judge is listening. We're arguing. And the judge sees the teacher and stops us and says, "Oh, can I help you?" And the teacher says, "Well, my kids are here, and we thought there's nobody else in the courthouse. We thought maybe we could watch." And the judge says, "Well, this is open court. You're welcome to come in. We certainly welcome you and would love you to come in. But let me just say this. This is the most boring stuff I've ever heard." The kids came in anyway, but I'm sure we bored them to ears. I hope I didn't do too badly for you all. So.
I think you did a great job, and we sure appreciate you sharing the wealth of information. I personally learned quite a bit and really appreciate these last couple hours. I'll just open it up before we close it. Anybody else in the room have any question for George? Okay. And I think what you provided, George, for us today was a good compliment to what we had last week. And just thank you so much. We really appreciate it.
Sam's a great guy. I'm always glad to follow him because he takes the limelight. Yeah. He's great.
Awesome. All right, and we'll just dismiss. Thank you.